better luck than I have.
And horses.
Yeah.
We seem to,
So.
we've got quite the bankruptcy program going on, so.
Yeah.
So, her husband came home one day and said, how much does the horse weigh, dear? That
We
we
may
could
or
cover
not
us, you
trust
know?
So we actually are able to offer.
Why horses?
So we have students coming out with quite the background, they're doing really well. A lot of bankruptcy clerkships and people going on.
Good morning. Welcome to the American Bankruptcy Institute. We're here today for the release of the final report and recommendation of the ABI Commission on Consumer Bankruptcy. I'm Sam Giordano, ABI Executive Director. Today's release is the culmination of 2.5 years worth of study and careful consideration by a cross-section of experts in the consumer bankruptcy world about ways to improve the consumer bankruptcy system. ABI is uniquely situated to do this kind of study because we're not only the largest organization of insolvency professionals, but we are not a lobbying organization. The report is unbiased and without partisanship. We are an expert in providing access to Congress about information that can improve the bankruptcy system, and this report, together with an earlier study that we did on Chapter 11, furthers that aim. Today what we're going to have is a panel of 3 folks who were very involved in the process, the co-chairs of the commission as well as the official reporter, who will describe the key recommendations in the report, and also a little bit about the process that led to the report's release. So with that, I'll turn it over to the Commission's reporter, Bob Lawless.
So thank you very much, Sam, and thank you especially for the support of the American Bankruptcy Institute in operating this commission. It's been a real pleasure to do it, and it's great to this morning. The report's been released, and what I'd like to do is introduce the co-chairs of the Bankruptcy Commission. First, Judge William Houston Brown, who is a retired U.S. bankruptcy judge from the Western District of Tennessee, and a former judge on the Sixth Circuit Bankruptcy Appellate Panel. Judge Brown is a well-known expert in Chapter 13, currently serves as the editor and advisor to the Academy for Consumer Bankruptcy Education, which is the education arm of the National Association of Chapter 13 Trustees. He is the recipient of the Excellence in Education Award from the National Conference of Bankruptcy Judges and the Judicial Excellence Award from the American Bankruptcy Institute. He's also the author of numerous texts, including the Bankruptcy Exemption Manual, and is the principal contributing editor of the Norton Bankruptcy Law and Practice Treatise. Judge Elizabeth Paris is a retired U.S. bankruptcy judge from the District of Oregon and a former member of the Ninth Circuit Bankruptcy Appellate Panel. She is a nationally recognized jurist who served on the Advisory Committee for Bankruptcy Rules of Procedure. She is a recipient of the American College of Bankruptcy's Distinguished Service Award, the National Conference of Bankruptcy Judges Excellence in Education Award, and the Oregon State Bar's Judicial Excellence Award. She is a leader in judicial education, a former chair of the Bankruptcy Judges Education Committee, and board member of the Federal Judicial Center. And as a reporter's privilege, I just want to say that I, of course, had met Judges Brown and Paris before working on the commission, and one of the great joys of this work is me getting to know both of you a little bit better and working with you. So what I'd like to do, our goal here is just to introduce the report and talk a little bit about some of its findings, but I think before we get into the findings substantively is to talk a little bit about where it came from and the process. Judge Paris, I guess I'd like to turn to you first and just talk a little bit about where the commission came from. It was an important priority for Judge Gene Wiedoff during his term as the American Bankruptcy Institute president. I just wonder if you could maybe talk a little bit about why this was a good time for the report.
First, let me say one of our joys as co-chairs was getting to know Bob Lawless a little better. So I want to thank you for all your hard work.
Yeah, there was just a little work put into this by Bob, so appreciate that.
So our code is now almost 40 years old, and it's been 14 years since the last major amendments, and a lot has changed. And the idea was to bring the code up to date and to improve the code. Just to name a few of the changes that have occurred, houses cost about 50% more in inflation-adjusted dollars than they did 40 years ago. In 2005, the date of the last major amendments, student loan debt was so small that it wasn't part of the Federal Reserve's monthly statistical release. How the economy works, how debt is incurred and collected, how professionals and courts operate, and the regulatory process has all changed since 2005. And technology plays a significant role in that change. Shortly after Gene Wiedoff became president of the ABI, he approached Sam Giordano, who's the executive director, about whether ABI would be willing to sponsor a consumer commission. Of course, you'll recall that the ABI had sponsored a business Chapter 11 commission. They convened an exploratory committee, and the exploratory committee recommended that now was a good time to have such a report prepared. Between then and now, there's been a lot of work done, and there have been a lot of people who deserve credit for this report, or demerits, depending on your point of view. But I'd like to give a shout out to two who provided our funding. They didn't particularly influence our decision-making at all, but they did provide our funding, and that was the ABI Anthony N.H. Snelling Endowment Fund and the NCBJ, our National Conference of Bankruptcy Judges Endowment for Education. And I really appreciate their financial support, because without them, there would be no report.
So we received a request to make sure the microphones are a little bit closer to us,
Okay.
so we will do that. So thank you, Judge Paris, and we've already mentioned Judge Wiedoff a few times in here. Judge Wiedoff, I think, would be here in the room and would be delighted to be here with us, but he is in another room right now talking with the media. And as you mentioned, right, there's, credit for this report goes to a lot of different people. I think it's a great example of many hands making light work. There were many, many people involved with this project. Also, Judge Paris, I was hoping you maybe could talk a little bit about the task set before the commission. It wasn't a free-roving commission. We weren't just kind of given a mandate to do anything. We were given a task with a specific goal. And if you could talk a little bit about that.
Our task was to suggest improvements in the existing structure. We couldn't just say, tear it up and start all over again. And the report emphasizes practical solutions rather than they could be reasonably implemented within the existing structure. And the recommendations run the gamut from statutory changes, changes to the federal rules of bankruptcy procedure and the forms, changes to administrative rules and practices, and recommendations on best interpretations of existing case law, and best practices for judges, trustees, and lawyers that can be implemented without any statutory change at all.
Right, thank you, Jim. And the language that's on the screen was actually the charge that came from the ABI Board of Directors. The commission was set up as an independent entity and given this task. And I think one of the things we should probably make clear is that when the commission speaks, it's speaking as a law reform organization. It's speaking as the commission. It doesn't speak for the American Bankruptcy Institute. It does not even indeed speak for any individual member of the commission. There was a broad range of views discussed during the commission, and I just want to emphasize that that doesn't mean any individual commissioner necessarily agrees with any individual recommendation. And in terms of setting up the commission, we spent 2.5 years, we were talking beforehand. Actually, it was about 6 months of work. The first half year of that was getting the commission up and running. And the commission, the way we structured it was to have a commission with 3 committees working under it. The 3 committees were roughly divided up according to the Bankruptcy Code, the idea of the Committee on Case Administration of the Estate, taking issues that were cross-cutting across all of the different chapters, Chapter 7 and 13. Then we had a committee on Chapter 7 and a committee on Chapter 13 that were focused more on those issues. As Judges Brown and Paris know, I was fond of saying these committees were not jurisdictional in the sense that that didn't mean that they couldn't take on issues that might overlap with the other committees, but we roughly tried to divide the work up as the Bankruptcy Code has it structured. The committees themselves had overlapping membership with the commission. We structured it so there were commissioners scattered on all the committees, as well as then committee members who were not on the commission. So the idea here was to have a broad base of discussion that had experts from many different fields, many different parts of the country. And the commission had to begin, of course, one of the ways we structured it this way was we had to begin to think about, okay, so what are we going to talk about? What topics should we discuss? And we used this committee structure to develop those topics. The commission, first asked its committees to develop topics. it was a huge list of topics that we initially had. We also solicited input from the public. We received a large number of emails and other suggestions. After we got all those, we took these ideas for topics, divided them up, decided which ones we were going to study, divided them up among the committees, which then developed reports. And we took those reports then and presented them to the commission. The commission tried to work by consensus wherever possible. The commission and its committees held 6 public meetings. As we went through the process, these meetings, we invited people to come and talk to us, give us ideas, give us, in some instances, some reaction of some things that we were working on. So we went through this process. We had these committee reports. The commission then would try to work by consensus, and then we had, at the end of the day, a commission recommendation that, after the commission had approved it, that then came to me as the reporter, and I would draft the commentary accompanying the recommendation, trying to use to the greatest extent possible the reports and everything that had been generated by the committees and the commission. The commentary then was posted for review and comments by the commission. We take those review and comments from the commission, incorporate them into a final draft. The final draft then was reviewed by the entire commission, which then approved the final draft unanimously. And given the way that it was, the commission was to operate, it was important that a diverse set of views be heard, Judge Brown. And how did the commission go about ensuring that these different points of views were considered?
Yeah, that certainly was very critical to the structure of the commission itself. I mean, in forming the commission, it was decided at the beginning that we wouldn't have active bankruptcy judges, for example, so that there wouldn't be, any theory or idea that the commission was reacting to people actually sitting on the bench today. There are several retired judges like Judge Paris and me that were involved as commissioners or chair of various committees. But in addition to that decision, we obviously wanted to be sure that there was a broad range of interest in the process. And so there, of course, were judges, retired judges, there were active trustees, both 7 and 13. There were lawyers, both on the debtor side, people representing consumer debtors, as well as attorneys representing creditors. There were auto credit people, mortgage credit people, unsecured credit people. There was a broad range of the type of interests that are involved in the consumer system. And as of course the title of the report itself says, this is a report from the consumer side. We didn't attempt to address business type issues. Rather, this is consumer issues. And so when you look at the range of people involved and across the country, there were people all the way from Oregon across the country to here, to the Northeast, the South, trying to make sure we had a full range of people, not only in their practice experience, but the varied practices across the United States. As we all know, even though there's one bankruptcy code, there's great variation in the practice, especially in the consumer area. We see this in, for example, Chapter 13, where some parts of the country have much more active Chapter 13 practice than other parts of the country. And so that's reflected by the membership on the commission and on the various committees. So as Bob mentioned, we had 6 public hearings. We had a lot of input, I think 131 submissions of possible topics and comments by people in the public through the ABI website or through public meetings that we had. So a great deal of input from a wide variety of the consumer interest.
So
go ahead.
Yeah. So I was going to say, so the report is now been issued. It's 10:15, so it's been out now for an hour and 15 minutes. And the outline of the report is on the slide. It's been divided into 5 principal parts. ideas about effectuating the fresh start. These are mainly, not exclusively, but mainly discharge issues, but also ways to think about how to make the bankruptcy system work better for people kind of post-bankruptcy. Issues about improving creditor certainty, things that are imposing costs in the system that are just making the system not work well really for anyone. Chapter 3 is about facilitating effective access. As the title suggests, these are about the gateways into bankruptcy court and about ways to make those gateways more effective. We have a chapter on Chapter 13, making Chapter 13 work better. And then the final chapter are systems issues about how the bankruptcy system works, how the courts works, how the clerk's office works, how different actors within the bankruptcy system might be able to be more effective. One of the things we should emphasize is that our discussion this morning is just intended to give some examples from the report. There are 48 discrete topics, and it certainly is not our intention to go through every one of those 48 topics this morning. Indeed, I'm not sure we'll get through our entire agenda in the time that we have. But what we wanted to do is to give some brief examples, and there's more programming for those who are going to be at the ABI's annual meeting. There's more programming, especially the Hot Topics presentation of the ABI Consumer Committee at 4 p.m. on this coming Saturday afternoon. But let's maybe turn to some of the topics that we have, and that's what we intend to do with the remainder of our time, is now start talking about some of the recommendations. And Judge Paris, one of the first things we want to talk about, of course, is the issue of student loans and student loan debt, which is, you mentioned that really before, it was about 2005, the government didn't even track the amount of student loan debt because it wasn't material. Of course, that's not true today. And people show up in bankruptcy court with lots of student loan debt, but the bankruptcy law limits the relief that the bankruptcy system can give them. And I was hoping you could talk a little bit about the Commission's recommendations on student loans.
Well, the Commission attempted to take sort of a middle ground approach. Not that we didn't have a debate about which approach to take, but basically we tried to protect student loans but make them dischargeable at a certain point. So we really wanted to basically roll back the clock to make them dischargeable after 7 years without a showing of undue hardship. And that is 70% of the usual 10-year repayment period. So the government will have its chance to collect for over 70% of the original repayment period. We wanted to protect non-students, the parents and grandparents, by making the debt dischargeable at the get-go. And we didn't see any reason why private student loans should be made non-dischargeable as they were in the 2005 amendments. So they would once again become dischargeable. And we wanted to improve the treatment of non-dischargeable student loans by turning them into priority claims, be it an 11th priority, so at the bottom of the list of priorities, but that would improve their treatment in Chapter 13 because now people could, there's a controversy as to whether you can separately classify and better treat the student loans, and you would be able to separately classify them under if they were a priority claim. Assuming that you can't change the statute immediately, we do think that the Bruner test, which is a case law test that's used in all the circuits except for, I believe, 2, can be better interpreted, more consistent with the wording of Bruner, and eliminating some of the judicial glosses. And so Bruner talks in terms of the original repayment period. Can the debtor repay within the original repayment period? And somehow by judicial gloss that has turned into over the debtor's working lifetime. And so we think Bruner should be rolled back, so to speak, to its original language. We think the debtor should get a reasonable standard of living, not a poverty level standard of living. Case law is divided as to what standard of living you use under the Bruner test. And the Bruner test should apply a preponderance of the evidence test, not a certainty of hopelessness, as some of the cases have done. And finally, we think that the bankruptcy judge's findings are findings of fact under Bruner and should be given appropriate appellate deference as findings of fact. And some of the appellate cases have not done that. And finally, if the student loans are not given a priority treatment by Congress, we still think that the fact they're non-dischargeable in Chapter 7 justifies a separate classification in Chapter 13.
Yeah, I think one of the things that should always be emphasized when you talk about bankruptcy law, because what the proposal here is to become that these student loans become dischargeable after 7 years. There'll no longer be a undue hardship requirement as under existing law. That's the Commission's recommendation. I was going to say is that one of the things that bankruptcy is not a free ride. Right? There are rules in place to ensure that people pay their debts to the extent they can. Right? This is not. The proposal here is not that someone who can pay should be able to walk away from a student loan after 7 years. Rather, if you can't pay, as determined by bankruptcy law, the loan becomes dischargeable as any other loan is dischargeable.
I think that's right. I mean, what we're trying to recognize is the practical reality that there is a justification for student loans being treated differently from a typical unsecured debt. But at the same time, there should be some point in time in which it's recognized that a debtor who can't repay the student loan in, for example, 7 years, is there a likelihood that she will be able to continue to pay it after that point in time? So we're not doing away with the undue hardship test in the meantime. There might be a debtor who could prove undue hardship in less than 7 years, but trying to find a point at which it simply typically would be recognized that this is not a debt that would continue to hang over the debtor forever.
The debts hanging over the debtor forever has a cost, and the report recognizes that cost. It's a cost in terms of lack of purchases of houses, cars, having children, and we just recognize that at a certain point, for those people who want to avail themselves of bankruptcy, they ought to be able to get the fresh start and move on with their lives. And we think it's 7 years, but there ought to be some point at which people can say, you know, I can't pay my full student loan and all the interest that's accrued on it. I want to discharge it and move on with my life.
Yeah.
So, Judge Brown, I was hoping you could also talk a little bit about the changes that the report suggests the Department of Education could make.
Correct, and this is, it's an addition to, but supplements, it's not inconsistent with what Judge Paris has just described in the terms of our proposed legislative changes. Actually, this part of our report came out some time ago when the Department of Education asked for public comments about its interpretations and applications of regulations concerning student loans. So we submitted that part of the report in response to the department's letter several months ago. And in that part of the report, we're basically saying much the same thing, is that the department should interpret its current regulations and perhaps add to those consistent with what Judge Paris has described, that there should be a recognition that these debts, while they're protected under the Bankruptcy Code from immediate discharge, it should be recognized that at some point in time they should be subject to discharge, and that in that interval the Bruner test, for example, should be interpreted and applied by the department in its regulations, that recognizes the reality that we're not trying to put debtors into a poverty situation. We're not trying to say that you should show hopelessness, rather that there is simply a recognition that some debtors are unable to repay these student loans. So, for example, part of our recommendations to the department include that the department should develop bright line rules in its regulations about such things as disability. If this is a debtor that has been recognized as being on total disability in Social Security, for example, or veterans benefits disability, that the department should recognize that that is a basis for administratively allowing a discharge of the debt. Of course, one of the problems we recognize in the report, it's been recognized not simply in this report but separately, that one of the problems of getting an administrative discharge of student loan debt through any process is that there's a potential tax liability still holding over these student loan debtors that a discharge in bankruptcy could eliminate. We also encourage the department in its regulations to not encourage its collectors to overly aggressively attempt collection. That they should, for example, recognize proof presented by a debtor of a disability or an inability to pay, inability to get a job, for example, that pays enough to repay the student loans, without going through expensive and extensive litigation. So, best interpretations of the current law, we also encourage the department to recognize that, the Broomer test, for example, that was described by Judge Paris.
Yeah, and I think one of the things we should acknowledge is there's, of course, lots of discussion about what should happen with student loans generally.
Yeah.
Right, and we have a piece of this, right, which is what happens in bankruptcy court. The commission report should not be read in any way as endorsing or being against broader reforms to student loan lending more generally outside of the bankruptcy context.
Yeah.
Right. So the next topic, let's maybe move to the next topic, and let me turn back to Judge Paris and maybe to talk a little bit about some of the concerns that have been raised about disproportionate Chapter 13 filing rates by African Americans and what the report says about that issue.
The report goes through that there is a disproportionate filing of Chapter 13s by African Americans, and there's been a lot of academic literature that African Americans are about twice as likely to file 13 as white Americans. And the problem with that is that 13 is more expensive. It requires payments over 3 to 5 years before you get a discharge, and only about 40% of people get a discharge, whereas in the high 90s get a discharge in Chapter 7. And the facts raise equal access to justice questions. And the recommendations of the Commission are the professionals should strive to assure equal access to justice, and that bankruptcy organizations should develop and disseminate education and training that helps bankruptcy professionals recognize their implicit bias, because we assume it is probably implicit, not explicit bias that is causing the issue. And Congress should amend the pertinent statutes to allow the collection through the bankruptcy petition of race and ethnicity information and the dissemination of that information by the administrative office. And absent that rule change, we think that the Rules Committee and the AO should consider collecting such information and subject to appropriate privacy considerations. And the idea of disseminating the information is at least we can have the discussion in an informed sort of way if we have the facts as to how many petitions are filed by what portion of people of different ethnicities and races.
And I think a lot of this is an awareness issue. It's as you mentioned, an implicit kind of bias that seems to be going on. And many times our experience has been in talking about this issue among the commission and in our public meetings is that, it's people are not aware of what's really going on, and so making this more of an awareness issue in itself would help to address the problem.
Yeah, I'm going to go ahead and move us to the next topic,
Sure.
not to give any of these short shrift, but I want us to leave some time for some questions at the end. So maybe we'll go through some of these remaining topics a little bit more quickly. Again, there are 48 there's 48 topics within the commission report, many of which have multiple recommendations. So we're just hitting some highlights here, and certainly, but one of the bigger concerns that we wanted to address were the issue of Chapter 7 filing fees. And Judge Brown, we were just discussing access to justice questions, and certainly payment to what people pay to access the justice system raises those access to justice issues. So if you could maybe talk about the recommendations.
Absolutely. It's not simply in this commission report, but there's been a lot of literature and discussion of this problem generally. As the current case law and code exist, an attorney representing debtors, consumer debtors in Chapter 7 has to either be paid in advance or perhaps not be paid, most likely not be paid unless the debtor voluntarily paid. Because if I represent a debtor and file a Chapter 7 and I haven't been paid my fee for doing that, then that's a pre-petition fee that's going to be discharged in that bankruptcy. And so the commission report talks about the problems of that and what can be done about it. And it's one of the issues in which we did not come out with an absolute flat consensus recommendation, but rather a range of choices, such things as that Congress should consider. Should the Chapter 7 attorney fees be accepted from discharge so that a debtor could enter into an agreement with an attorney to file a Chapter 7 case, but the fee would be out there to be paid later and would not be discharged? Or should the discharge perhaps be delayed for example, 6 months to allow a debtor to voluntarily have 6 months or some period of time to pay that fee after filing bankruptcy? Or did we continue with what's currently happening, that is encouraging people to file Chapter 13, because in Chapter 13 they can pay the attorney fees through the Chapter 13 plan over a period of time, when really Chapter 7 might be the relief they really need. And so we do make proposed recommendations that Congress should consider in addressing this problem, but it's a very prevalent problem that's encouraging people into Chapter 13 when really Chapter 7 ought to be the relief they need.
And Judge Paris, the other kind of side of this coin is ensuring that people have competent representation once they're in the system. And could you talk a little bit about what the Commission recommends there?
Well, the Commission doesn't recommend any changes to the discipline rules because the Commission goes through, the report goes through 9 different rules and statutes that potentially can be used to deal with misconduct, and advocates that they be more vigorously enforced. And towards that end, the report advocates that local committees be formed to deal with misconduct. As it stands right now, the judge has to prosecute somebody, and you're in a strange position where you're the prosecutor, the investigator, the arbiter, and then you write your opinion, and you know that that's like your brief on appeal, and it really isn't a good situation. You want your arbiters to be arbiters, and we want uniform docketing of discipline orders so that they are researchable, and you can identify who it is, which party. And we want the AO to put out an annual report identifying the parties represented on the theory that Brandeis had it right, that sunshine is the best disinfectant. And to encourage competency, we want to give a little reward economically to those lawyers who go ahead and get board certified.
Yeah, it is important, I think, to stress this is addressed not just to debtors' attorneys, but to attorneys representing creditors. I mean, any abusive representation or lack of representation is what we're trying to address here.
Yeah. It's a good example of an issue, I think, that demonstrates why it was important to have a diverse set of people in the room, because as Judge Paris mentioned, there already are robust rules in place to address attorney misconduct. And I think a lot of the discussion focused on a lot of the practical obstacles that happen on the ground. And so the next topic we're going to talk about is the idea of a reserve fund in Chapter 13, because a Chapter 13 debtor usually can only receive a discharge if he or she completes the Chapter 13 plan. But debtors, of course, can have unexpected setbacks during the 3 to 5 year life of a Chapter 13 plan. And this idea of a reserve fund was the Commission's way of addressing that problem. And Judge Brown, maybe if you could elaborate.
Yeah, briefly, what this proposal is about is the idea that recognizing that debtors in Chapter 13 who are going to be in the case perhaps for 3 to 5 years will have changes in their financial circumstances. They might lose a job, they might be off work temporarily for illness or whatever, and what happens if they have an unexpected expense, a home repair, an illness, a medical bill, things of that nature. And so there is some courts, a few courts have adopted the practice of allowing those debtors to set up a reserve fund. And the Commission suggested that's a good idea. That's an idea that other courts should explore and should perhaps adopt. And perhaps the idea is it's not an unlimited amount of money. Our recommendation is perhaps a month of scheduled expenses. In other words, the debtor shows I have X amount of money each month that I'm spending on expenses for my home, car, etc. And perhaps a reserve fund could be funded as part of the Chapter 13 plan that would be there and allow that debtor, if the debtor has an emergency or has such an unexpected expense, to notice all the creditors, notice the trustee, I need to use some of that money for this expense, and then perhaps replenish the fund. And we also make a recommendation. What happens to that money at the end of the case? And it's not just going to sit there forever. Sooner or later it either goes back to the debtor or goes to creditors at the end of the case.
So let's maybe talk about 2 more topics and then throw it open to questions. Yep. And the next topic, maybe Judge Brown, you can talk a little bit about what the Commission recommends with the means test, which is, of course, was a controversial centerpiece of the 2005 law.
Yeah, it's a complicated thing to talk about. We're happy to answer questions about it, but this was part of the 2005 Act to set sort of a threshold for entry into bankruptcy, if you will. And underlying thrust of it is that Congress was saying if we have a debtor who is able to pay creditors, then that debtor should be encouraged to pay creditors. And so the means test is a mathematical formula that starts with current monthly income and then takes some expenses that are deductible using largely the IRS standards for such things as home mortgages and auto loans, etc. But the recommendation of the Commission is not to do away with the means test, rather to make some modifications to it, to recognize some problems with its application, and to try to some extent simplify it and make it more efficient. So for example, for those debtors who are what we call below median, that is their income, monthly income, is below the average median income for households of that same size in their location. That's a number, by the way, that's established and published generally. That those debtors below median there should be a reduced documentation. They shouldn't have to go through all the steps. If they're below median, they're already living at a lower income level, and they typically shouldn't be required to produce a lot of documentation that's expensive. The means test should exclude, not right now, the statute excludes Social Security, for example, income. But it doesn't say anything about other government disability programs, veterans disability. That should be a part of the means test so that that's excluded. If a debtor's own disability, a government-based disability, that's already an established reduction in income and should be recognized. Should be, if there's special circumstances, we should recognize the reality that just because the debtor entered into this obligation voluntarily, student loans is a great example. There's some case law that says because the debtor entered into this student loan voluntarily years ago, that's not a special circumstance that should be allowed to deduct that payment from the means test. And we say that our recommendation is that should be considered. So the bottom line is the means test is still there under our recommendations. It's recognized as having some valid purposes, but we're trying to modify it, recommend to modify it that would encourage the means test to be more efficiently applied.
Yeah, and then maybe one last topic, we'll just throw it open then for general questions, Judge Paris, is to talk a little bit about the credit counseling and mandatory post-bankruptcy financial management course, which were also part of the 2005 law.
And the idea behind the 2005 law was that people should know their options going in. And if they understood their options better, they might not choose bankruptcy. Well, those of us in the field find that most people are so far in debt by the time they file bankruptcy that they have no option. And the debt repayment plan that the counselors are supposed to generate, rarely are the debt repayment plans ever generated. So we recommend doing away with the ticket in, so to speak, the pre-briefing. Something like 85 to 90% of individuals issued a certificate actually file bankruptcy. And so the vast majority do file bankruptcy. And the Commission viewed this as from a cost-benefit standpoint. It costs everybody, not just the debtors who pay for the certificate and go through the class, but also the U.S. trustee who certifies the agencies that do the counseling. And it creates traps for the pro se debtor who isn't aware of the requirement. And so we just didn't think that it was worth the time spent and the cost. As to the financial management class, we were divided. We recommended doing away with it in Chapter 7 and making it a more needs-based. If people wanted to do it, they could do it, and under the Fair Credit Reporting Act, if bankruptcy is reported, they would have to report that somebody completed a financial management class. And if the marketplace, through an improved credit score or otherwise, rewards those debtors who complete a class, then debtors will be incentivized to do it. So it's a market-based solution rather than a mandated solution. In Chapter 13, there was more division, and we did not recommend doing away with it. Many trustees offer the financial management class. They do it early on. People need to live on budgets for the 3 to 5 year period. We just recommended that there be studies as to whether having a class early on encourages completion of the Chapter 13.
Yeah, and I think that's it's a good point to mention that you will see in the report, it's a well-documented, footnoted report. When you look at pre-petition credit counseling and the post-petition pre-discharge financial management, there's a lot of academic studies in this area. And so in Chapter 13, our recommendation is, okay, if it's going to be retained in Chapter 13, we encourage further study to see, does it really make a difference? Is it really contributing to more discharges, for example, in Chapter 13 or not?
So with that, those are some of the recommendations we've discussed that we talk a little bit about, but let's just throw it open to questions. And just like to remind anyone who's watching the stream that they can go to consumercommission.abi.org, and there's a form there, and you can submit a question yourself if you're watching the stream, and it's going to pop up on my screen, and I'll pose the question if you submit it there. But we also have people who are here who might have questions, so let's open it up to general questions. Yes.
Yes.
Who's going to get the report?
Very good point. Obviously, it's published today. It's public today. It's available, I think, right now on the ABI website, so that you can easily click and download the report. And the spring meeting, the annual meeting of ABI, of course, starts today at the Marriott downtown. And so there are several aspects of the program that will be discussing the report. It will be mailed, I assume this week, Sam, to every bankruptcy judge. It will be mailed to, of course, the people that were on the commission and the committees, committee members who are across the country. And I suspect that you will start seeing it talked about, well, I know you will, in seminars around the country where people will be talking about it. So the bottom line is we're going to be all making an effort, ABI making an effort to get it as widely disseminated as possible. And congressional staff will get it very quickly, I know.
Yeah, I'd encourage anyone who's interested to go to the ABI website. Sure. If you haven't already. Fill out you have to enter your email, and the report will show up in your inbox. And as Judge Brown said, it's widely available. Anybody who wants the report can have a copy.
You plan on disseminating it to trustees, or?
So the question is, I should probably repeat the question. So the question is, do we plan on disseminating it to trustees? Well, so absolutely. If you're asking about physical copies, I don't think there are any plans to physically mail copies to trustees. One of the seminars you spoke about is you and I are on a panel.
Yeah, that's right. Bob and I are on a panel for the National Association of Chapter 13 Trustees, their annual meeting this summer, and several other commissioners are on that panel that will be presenting a 2-hour block of that program on the report itself. But I know, for example, trustees, both 7 and 13 trustees, have been watching this process. Well,
I think I should point out even more that 7 and 13 trustees were commissioners and committee members as
correct.
Well, right?
So I think you will see the the trustees across the country will be watching for this and will be getting downloaded copies themselves very quickly, as well as through seminars.
Implementation of the report will depend in part on getting the report far and wide, because we're going to be counting on lawyers, judges, legislatures to implement these recommendations that we've made. So we have an interest in making sure that the report is disseminated far and wide.
Yeah, obviously one of the things that will be interesting is many of the recommendations may be coupled with, we recommend Congress should do this, but if Congress doesn't, or in the meantime, the best interpretation of the law is this. And so obviously that encourages getting it out to sitting judges and lawyers so that they hopefully recommend taking those positions.
Yeah, I think I counted up part of the question, I think, is how we're going to make sure this gets disseminated broadly to legal professionals. And I think I counted up there were 52 people that were involved with the commission, either as committee members or commissioners, and we had the map, and they're from all over the country. And there are local bar organizations. I know all of us are speaking to some of them. We hope commissioners and committee members do the same as well and use the report.
We're running stories on it and putting in links.
Excellent.
Oh.
So excellent, yes. So other questions?
What was perceived to be the most poorly working part of consumer bankruptcy? bankruptcy, and what part, but the opposite, what part did commission members disagree on most?
So there are two questions. What was perceived to be the most poorly working part of consumer bankruptcy, and what issue did the commissioners disagree on most? So I don't know if either of you want to take a stab at that.
Well, let me start by saying I don't think it would be an accurate description of this report to say this is just a reaction to the 2005 amendments. This is a reaction to the current state of the law, whether that's the 2005 amendments or the 1978 code coming forward. I think obviously student loans was a big part of the discussion. Attorney representation and good representation, access to justice, all of those were really important parts of the whole picture, I think.
Let me say this, the solution to a lot of sick people is not to close the hospital. And that has been somewhat the reaction. Oh, student loans, that's a big problem. Let's just make them non-dischargeable. Well, bankruptcy might not be a solution, but you still have the debt problem. And so we attempted to deal with it in a balanced sort of way. And to recognize that there is some cost to closing the bankruptcy gate, so to speak.
Yeah. When part of your question was, I think, what issues created the most division, this was a very cohesive group that worked hard at consensus. I would say some of the more difficult issues were such things as, how do you pay Chapter 7 debtors' attorneys? I mean, when you start talking about that issue, you're going to get a wide range of opinions, like, well, let's don't pay them at all, to let's guarantee they can be paid. So I think it wouldn't be surprising that's the type of issue in which we didn't come to an absolute consensus. Rather, we said, here are some choices that Congress could consider in making, if they're going to make changes to the code. Yes?
Yeah, go ahead.
I'm thinking about the recommendations about violations of the automatic stay by retaining repossessed collateral,
right,
like cars. I'm wondering if any municipalities participated in your discussions, like Chicago, for example.
City attorney. Well, there were certainly. So the question had to do with the issue of repossessed automobiles and bankruptcy, which is a currently big hot topic, especially in the city of Chicago. And the question was whether municipalities participated. And I think, frankly, I don't remember there was any city and municipal attorneys on the panel. But one of the things I'd like to point out, that issue actually cuts across. It's not a city of Chicago issue, right? It's actually a secured creditor issue. It's just so happens that the city of Chicago is aggressively pursuing the legal positions on that issue. And there were secured creditor and attorneys who represent secured creditors involved, including automobile lenders. So I think that point of view was well represented within the commission, even if there wasn't a municipal lawyer on the panel.
Yeah, I agree with that. I mean, certainly the commission was well aware of the Chicago situation, as it would be having any discussions about this because it's gotten so much coverage. And that's a good point, by the way. It's a good illustration of the kind of issue that we didn't have time to talk about today, is that I think that the recommendations there represent a good balance, where we were trying to get for the debtor who needed, for example, a car or other repossessed collateral to get it back for being able to get to work, but at the same time offer some protection, some more uniform protections for the creditor, to be sure the creditor either was sure of having insurance, or if the creditor had a lien like the city of Chicago, that lien was protected through the bankruptcy process. And there's just great variation around the country on that, for example. So we were many of our recommendations are trying to make more practical and uniform recommendations.
So if I can, I mean, we've got a question that came
Sure,
on from online. The question is, the report recommends to double the Chapter 7 trustees' case fee, which is a recommendation we didn't have a chance to discuss, and that's true. And the question points out the source of the funds comes from existing fees. How feasible is that? I foresee programs benefits getting cut should funds be diverted in this matter, but uncertain as to what those benefits might be. Right? I mean, I don't think the recommendation actually says that we would come from existing fees, but that there was a sense that there was enough revenue in the system to support this. But the question they foresee, well, let me just ask the question, which is really, how feasible is that?
Well, that's a good question. I mean, what we're talking about is increasing the Chapter 7 trustee fees, commissions, correct?
Which is $60 a case right
yeah,
now.
which hasn't been increased in forever, it seems like. And how do you fund that? Well, obviously, one solution is to increase the case filing fee. There's certainly not an acceptance of that idea by the debtor interests. And it was the sense of the commission that there are sufficient funds generally in the Treasury to permit an increase in payment of Chapter 7 trustee fees. And that's the position that the commission took. How feasible is that? Well, I think it's a reality that that's a difficult issue, and Congress would have to decide how it wants, if it were going to increase the fees, how it was going to fund it.
It's important to remember that if a debtor files Chapter 7, the filing fee is over $300 at this point.
Yeah.
And it just isn't feasible that it would go up by $60 for these people who can't afford the fees and the lawyer's fees.
Yeah, the report talks about there's been an increase in the Chapter 7 filing fee from which the Chapter 7 trustee fee is paid, and as Judge Brown mentioned, the trustee fee hasn't been raised since the early 1990s, and I think there's a real sense that, well, it obviously hasn't kept pace with inflation.
Yeah.
I think approximately worth half of the value it was when it was enacted, and that this is a real problem for the bankruptcy system. If you want a system to run, you've got to pay the actors in it, and Chapter 7 trustees are important actors in the bankruptcy system. So
but it was pointed out to us that we not only needed to increase the share that came out of the assured amount per case, but also the percentages.
Yeah.
And the report recommends both.
Yeah.
So,
Yeah.
How realistic is it that lawmakers in the department will put in the student loan recommendations? And do you have any plan from this point on to follow up on what you've recommended?
So there are two questions. How realistic is it that lawmakers and the Department of Education will implement the changes, and what are our plans for follow-up? So I was going to say those are different questions, but I'm not sure that they are different questions. We could talk about both of them. So I think, let me make that broader, right? Is how realistic is any of these changes are going to get adopted, and what are our plans for follow-up?
That's a very valid point. It's a point that some people very close to me have asked me, why are you doing this? Who will pay attention? Well, none of us expect that tomorrow Congress will say, wow, what a great report. Let's enact all of that.
Yeah, maybe on Saturday.
Right? But it's a process over time. I mean, if you look back at the Chapter 11 report, the ABI's Chapter 11 report, it's been cited quite a bit by courts, including the Supreme Court, in the decision-making process. So one of the realities is you hope that over a period of time you do influence the system. Sure, it would be great if Congress would act on some of these things from our perspective, involved in the commission, but it doesn't require that necessarily. There are many of these recommendations that are rule proposals, so that means the Advisory Committee on Bankruptcy Rules will take them up and look at them. They're already looking at our proposal on Bankruptcy Rule 3002.1. So I think, we understand that the reality is this is a process that will take time, that over a period of time, will it make a difference? We hope so. How will we monitor it? I suspect we'll be monitoring, individually, we'll be monitoring just from the standpoint of involvement in seminars and discussion. I suspect this week we're going to hear reactions all the way from, were you crazy when you recommended this, to why didn't you recommend more? The range of reaction is going to be broad.
But to address the student loan issue specifically, clearly it's a topic that is getting a lot of press right now, in part because of the large amount of student loan debt and the growing amount of student loan debt. And so I suspect that there will be proposals, there will be hearings, and we have now put in our proposal, and the ABI will monitor what comes up and will supply witnesses when the time comes.
Yeah, and as far as the Department of Education, they got quite a number of recommendations, not just ours, in response to their letter. I've forgotten the exact number. It was in excess of 100, and haven't seen anything yet in reaction to all of that.
Yeah, so I don't know if you have anything else to add, but we're at the end of our hour. You have anything, concluding thoughts? So, I mean, we commented before we began that this is kind of fitting that we're here discussing the report in the very room where this began 2 years ago, where we had our first board meeting. Room was configured a little bit differently that day, but it's been I was going to say challenge, but that makes it sound like it was something that was insurmountably difficult, and that wasn't true. But it's been a real learning experience. It's been hopefully what's come out of the commission will have some effects, kind of along the lines of the last question. I agree with everything you said about what comes next. And we thank everyone for their valuable time today and taking the time to listen to us or to come here in person. And with that, we'll sign off. So thank you.
But for those in the room,
Yeah,
we're
I'm
happy to still
stay.
talk to you.
Stay, yeah.